Cuba crushes American Tobacco Company. A commercial empire shook this week under the weight of a story that not even 100 cedar wood boxes could hold. The Cohiba brand, born in 1966 in the heart of the Cuban Revolution, woven with fermented leaves of tradition and national dignity, has just legally sunk General Cigar, the American giant that for more than 4 decades trafficked with the symbol of the finest tobacco in the world, as if it were its own. The U.S. District Court for the Western District of Virginia was the stage where Judge Leonie Brinkema, in a crushing ruling, validated the 1929 Inter-American Convention as a shield of legal sovereignty for Cuba. The same Cuba that never could sell even a single box of Cohiba on U.S. soil due to the economic blockade is now recognized as the legitimate owner of a brand the United States tried to legally steal since 1978. It was not just a ruling, it was a historic slap in the face to the heart of corporate imperialism. Stay with us until the end, because what you are about to hear could change the way you see global power. Next, we will give you the details you need to understand what is really happening and stay one step ahead. This is News for Dummies, where we explain everything to foster your critical understanding of current events. Cohiba is Cuban. A slap to the empire, a steel pulse between a blocked country and a millionaire tobacco company based in the United States. Cuba, the country for its history, its dignity, and its hand-rolled tobacco leaf, prevailed. Judge Leonie Brinkema of the Eastern District of Virginia put an end to a 30-year-long arrogance scam. She validated that the Cohiba brand is not an empty label, but identity, revolution and victory over a legalized model of dispossession. General Cigar, which has exploited in the United States a fictitious version of Cuba's most prestigious cigars for over 4 decades, saw its registration cancelled. There is no ambiguity anymore. Cohiba is not just a name, it is a historic right. Cuba Tobacco, the Cuban state company that manages the Habanos brands, began its fight in January 1997, but its legal grounds date back much earlier. The brand was registered in Cuba on May 31, 1972, after being applied for in September 1969. It was born in 1966, reserved by Fidel Castro for gifts to heads of state, and it wasn't until 1982 that Cohiba went commercial with the prestige it had already earned. It was then, amid the fever for exotic brands, that General Cigar applied to register the name Cohiba in the United States. They did so in 1978 and succeeded in 1981, legally usurping a brand that already had an owner and birthplace in Cuba, but was still a living, latent, coveted brand. General Cigar's argument was as brazen as it was revealing, as it claimed Cuba had abandoned the brand by not commercially using it in the United States during the 1970s. This was the legal equivalent of accusing a victim of leaving their car with the keys inside after being locked in a cell because they could not legally sell their products in US territory due to the same blockade that prevented them from maintaining that presence, which was now demanded as a requirement. A perfect trap designed to eternalize the theft. But they did not foresee the 1929 Inter-American Convention on Trademarks and Commerce. Judge Brinkema not only dismissed General Cigar's arguments, but also backed the prior decision of the Trademark Trial and Appeal Board that had already cancelled General Cigar's US registration in 2022. This ruling was reaffirmed by the judge's decision. Her ruling is unequivocal, and in her statement in the Eastern District of Virginia Court, she said that since General Cigar had knowledge of Cuba Tobacco's use of Cohiba for cigars in Cuba, the court determines that the Trademark Trial and Appeal Board validly cancelled General Cigar's registration. What do you think about the impact this legal ruling might have on other countries facing sanctions or economic blockades trying to reclaim their intellectual property rights in foreign markets. The story cannot be told without the imperial context that supports it. Cohiba was from its inception a symbol of political prestige during the Cold War. While the United States multiplied its embargoes, handmade cigars were prepared in Havana to gift world leaders. Fidel turned tobacco into a diplomatic tool and a symbol of identity. That is why when Bill Clinton approved new restrictions on trade with Cuba in 1992, General Cigar took advantage of the hostile climate to position its fake Cohiba, a flawed imitation without aroma or history, in Manhattan's most luxurious stores. Exploiting the legal loophole, they profited with impunity. The US press, rarely inclined to recognize symbolic defeats, remained suspiciously silent after the ruling. But the information appeared in court records without room for doubt. Cuba Tobacco won. The giant was defeated. Although General Cigar has already issued a statement expressing disappointment and intention to appeal, this real victory is spreading like a fresh breeze through Havana's La Habana house and also sets a precedent. It forces the registration of intellectual property concepts under blockade conditions. Can a nation that cannot freely trade due to external sanctions also be denied the right to its most iconic brand? This is no minor detail. The 1929 Inter-American Convention was signed long before the current tensions between the United States and Cuba existed, and the same convention establishes the priority of the First Nation to register and use the brand within its territory. This cannot be ignored just because the beneficiary country is prevented from trading for political reasons. This judicial ruling also shakes the foundations of the global corporate narrative, because General Cigar Company is not a local United States company, but a subsidiary of Scandinavian Tobacco Group based in Denmark, one of the largest tobacco conglomerates in the world. This usurping economic power structure has been using legal loopholes for decades to appropriate commercial signs from peripheral countries. In the case of Cohiba, it was a manual operation registration in the United States, sales under the American flag, millionaire marketing, all while blocking the true producer. As early as 1977, Forbes magazine mentioned the Cohiba brand, even before its commercial launch in 1982.
Breaking news.
In other words, the symbolic press presence of the brand already existed. It was a product conceived from its inception as a symbol of Cuba, a brand associated with luxury, power, and status. That is why General Cigar coveted it. They did not want just any brand. Today, with this decision, the United States recognizes, even if judicially, that its use was improper, that Cohiba belongs to Cuba, that Cuba Tobacco never stopped using its brand, but was prevented from doing so, and that the economic blockade cannot be used as an excuse to steal intellectual property rights. Back in 2006, a federal court had already given Cuba a partial victory, but that ruling was overturned on appeal in 2014. General Cigar's strategy was always to delay and wear down, but this did not happen with the 2022 ruling by the Trademark Trial and Appeal Board and the ratification by Judge Brinkema. The strategy collapses. Regis Broersma, director of Scandinavian Tobacco Group, had no choice but to express his frustration, saying, "Of course, we are disappointed by this decision," but his words, far from reflecting usual arrogance, indicate a bitter defeat. Regis Broersma of VO. Of course we are disappointed by this decision. Appealing will not be easy this time. Legal arguments will not bow to the weight of the dollar. In Havana, the news was received as what it is, a symbolic restitution. Cohiba is more than a brand. It is the story of a country that resisted, that did not surrender despite blockades, regulations, and media wars. The judicial victory does not eliminate the blockade, but exposes it, leaving it bare as a system designed to exclude and steal, which is what General Cigar did. But it's over now. The world can once again look at Cohiba as what it has always been, a cigar born in Cuba, rolled in Pinar del Rio, aged with time and pride. It doesn't matter if it still cannot be sold in Miami or Boston. What matters is that the law now recognizes it as Cuban, and that is no small thing. This case sets a legal precedent and opens a breach in the commercial dominance narrative, because if Cuba can recover its brand amid the blockade, what prevents other sanctioned countries from doing the same? How many African, Latin American or Asian brands have been registered in the United States by multinationals just by signing a form? This time, the smoke was not sold by the usual suspects. This time, the story set fire in court and left ashes in the pockets of a company that thought it could buy everything, even dignity, but failed against the Made in Cuba seal. Now it's your turn. If you found this analysis revealing, leave us a comment with your opinion on how legal rulings like this might affect other countries under sanctions trying to protect their brands. Could this be the beginning of a new wave of intellectual property restitution worldwide? Subscribe if you haven't already, and hit the bell icon so you don't miss our next video, where we'll explore more cases where law meets geopolitics and economic power. And if you want to learn more about the history of the Cuban embargo and its global impact, click the video on screen now. I promise it will surprise you.